9-7, State of Texas versus Chardonnay Leanne Lockhart. Can I have parties announced for the record for the state? Defense.
Andrew Frederick, Ms. Lockhart.
Are you Ms. Lockhart?
Yes.
Counsel, have you received all the discovery and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Lockhart, I'm showing you what's entitled Application for Deferred Adjudication or Community Supervision. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
I'm going to show you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
I am a female. You keep saying yes, sir.
No, I said yes, Your Honor.
No, you said yes, sir.
I said yes, Your Honor.
I would
Okay.
say, I heard yes, Your Honor, as well, Judge.
Okay. All right. Are you proceeding on the,
One moment.
are you proceeding on the indictment as presented?
Judge, we're going to go with the lesser included offense of attempted arson, recklessly causing damage.
Okay. Any objection?
No objection.
All right, I'm going to show you what's entitled Court Admonishments. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
All right. Oh, you're right. She did say yes, Your Honor. I don't know why it sounded like sir. And my allergies are really, I apologize. My allergies are really acting up today.
And Judge, I whispered to her that she needs to speak up and not see it. So she knows.
Okay, that's okay.
Thank you, Your Honor.
Because sometimes people always say that and I'm like, what? All right. Did you understand the state is proceeding on the lesser included offense of attempted arson, recklessly causing damage as a state jail felony? The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes.
Actually, Judge,
I believe, Judge, since it's attempted, the arson, recklessly causing damage is a state jail, and since it's attempted, it's a Class A misdemeanor.
Okay, why do you guys have this filled out as a state jail?
It should have been
the
changed.
first paragraph specifically should list it as a Class A.
All right, so you all need to redo this piece of paperwork.
Sure.
And I would suggest that you use the felony paperwork. That way you can write it in because otherwise
It's difficult.
I don't have knowledge that she knows that it's a Class A because that's not how it's listed.
That first paragraph I wrote A right next to it. That's my handwriting. First page, Judge, and it says range of punishment, and it listed up to a $4,000 fine and up to a year in jail.
Oh, okay, you are correct. Look at
Every
this.
once in a while, Judge.
Corrections are happening. I appreciate it.
I hate to correct you, Your Honor.
That's, no. Here's the thing. I always tell people,
Sounds good.
make sure that if I'm saying something that's incorrect, to let me know, okay?
That's what you did there.
All right, so this is what I'm gonna need you all to do though.
Yes,
I
Judge.
need her to initial it so I know that she knows because all of this is state jail felony paperwork. That's why I say
Okay.
state jail.
Sorry about that, Judge. I saw that. I thought about using the other paperwork, but I didn't know if that was probably the better way. From now on, I'll probably try and do that.
Okay. Because all this paperwork is state jail felony paperwork.
I tried crossing out, it was the felony, the discussion about the felony, with the felony in possession of a firearm. And I thought I caught everything else. I think I changed everything to reflect.
Yeah, we
Okay.
erased all of the stuff about the firearm possession because that doesn't apply because it's not a felony.
Okay, let me carefully read through the paperwork. Just give me a moment. All right, they're charging you as arson as a Class A misdemeanor. The range of punishment for that offense is up to $4,000 fine and up to a year in Nevada County Jail. Do you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court doesn't have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you enter a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you are giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Did you understand that the court were to grant your application for deferred adjudication? If for any reason your deferred adjudication were revoked, the court only has the authority to sentence you up to 1 year in the Bexar County Jail and up to a $4,000 fine?
Yes, Your Honor.
All right. Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
If I could answer a little bit more, Your Honor. Yes, I do believe she does. She's mentally competent. She was done a psych evaluation for competency a few months ago. She has been found competent after discussing the case with her today and last week as a jail visit. I agree she is competent.
All right. So she's already been to the magistrate's court and they deemed her competent?
That's correct, Your Honor.
All right. Do you believe she was sane at the time of the offense?
Yes, Your Honor.
Ms. Lockhart, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
All right, the court will find that defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page, did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Okay, according to the plea, the state is proceeding on the lesser included offense of attempted arson recklessly causing damage. They're recommending deferred adjudication. They're taking in consideration County Court Cause number 634806, and there's to be a MIC evaluation. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
Yes, Your Honor.
State?
Yes, Judge.
I'm showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
There you are.
Next, I'm showing you outside the plea bargain agreement. State is recommending that your deferred adjudication be for a term of 2 years and there be a TAP evaluation. Did you understand?
Yes, Your Honor.
Okay. Did you understand that those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
All right. Then to the offense of attempted arson recklessly causing damage, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
State offer state exhibit 1 and all attachments.
No objections.
All right. I'm going to show you what's entitled Wavering Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, the court will find there's sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
That's to follow the plea bargain.
All right, Ms. Lockhart, if you're released from custody, do you have a place to live?
Yes, Your Honor.
Where?
7 more.
No, I'm sorry, don't say the address,
Oh,
but who will you be living with?
I apologize. It's a property my father had bought me.
Sorry, what?
I'll be living by myself.
Well, whose property is it?
My father.
Why were you not living with your father before? During this incident?
No, it's because I'm 30 years old.
Well, no, here's the thing. I'm reading this and it appears, rightly or wrongly, the way I'm reading it, it appears that you were homeless. It says that you started this fire because you were trying to dry a blanket. So I'm wondering why you were not living. Well, no, that's what they say you told them. It's in the police report. So I'm trying to figure out why were you homeless and why would your father let you live with him now? Here's the thing, Ms. Lockhart, you need to be honest with me because I'm trying to figure out your conditions. And let me just tell you, 1 or 2 things are going to end up happening. If I don't believe you're going to be honest with me, this is going to be set for a PSI. You're going to be sent back to the Bexar County Jail. They're going to do a PSI report and I'll get it when I get it, which will probably be within 8 weeks. So you need to answer my questions and you need to answer my questions honestly. Now, in this police report, basically it's implying that you were homeless because it said there were clothing and other items, and that you lit this fire because you told them you were trying to dry your blanket. So this is what you stipulated to. I didn't force anybody to stipulate to it. That's what's in the police report. So why were you homeless if now you can live with your father?
I wasn't at home, but I was not homeless.
So why were you living in this field or wherever it was with your items?
I have no idea. I don't know how to answer that.
All right, so why is she wearing yellow today?
I'm pregnant,
Okay, I just wanted to hear it. And how far along?
like 21, 22 weeks now.
Judge, I didn't mean to be presumptuous, but I have been in this court once or twice before. I did tell her she was going to be taking a parenting class, which was theoretically outside of it, but she understands she's going to take the parenting class going forward, because that's going to be her.
All right, and is she on medications at the jail?
Yes, Judge. She was not on her medication at the time. Now she is on her medication. She's frankly alive. She's definitely competent at this point in time. At the time, she was not being rational, but at this time, she is going to be successful going forward. There is the part about the mental MIC caseload and her being interviewed for that. I believe that would be necessary. And she understands that being med compliant is going to be a part of that as well.
All right, do you have any other children?
Yes, I do.
How many?
2.
And where are they?
Out of town with my family.
And what are their ages?
11.
They're both 11, twins?
Mhm.
That's either yes or no.
Yes.
All right, this is what, is there anything else from either side? Do you know if she's receiving SSI now?
I don't know.
All right, I'm going to sentence you to 2 years deferred adjudication. I'm going to want felony drug court referral. They should be able to do it because it's 2 years. And I'm going to want a MIC evaluation. Those are to take place while in custody. And then I'm going to want a referral. If she's not approved to MIC, I want a referral to Center for Healthcare Services, parenting classes. Take in consideration County Court Cause number 634806. 80 hours of community service restitution. Once she completes parenting, that will be satisfied. Regular reporting by Zoom or in person. Regular UAs. And I'm going to want a TAP evaluation in custody as well. If TAP recommends inpatient treatment, we'll start her with intensive outpatient treatment. And I'm going to want field visits 1 time per month until further notice. Probation will do proof of employment within 30 days of release, or proof of SSI within 30 days. There's to be no employment as a home health care provider or with minors. And I'm sorry, instead of the regular UA's probation, I'm going to want the UA hotline with testing at least once a week. Probation, is there anything else she needs?
No, Your Honor.
Is there anything else you need from the court to be successful?
No, Your Honor.
Counsel, do you think there's anything else your client needs?
There's nothing else she needs, Judge. We asked that the evaluations be done when she's out in custody.
All right, that will be denied. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, yes,
All
Your
right,
Honor.
because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Right, yes, Your Honor.
All right, we can go off the record. Was she not approved for mental health court?
Honestly, can't tell you off the top of my head, Judge. Since she's been in custody this time, we've conferred with the DA, and this is the attempt. She's got quite a bit of time. So this is our agreement that we reached.
All right.
She was approved. I know that she's being evaluated for mental at the MIC caseload, being that it's a misdemeanor, but mental health court, I don't think that was the approach because there wasn't an option to be a misdemeanor until we talked about the last week.
All right, probation, can you also do a referral to the mental health court? And see if they'll accept her. My understanding, mental health court, it's sort of like PTD. So if they accept her and she completes it, then this will be as though it never happened. So counsel, if they accept her in PTD and you all want to come back and ask for a motion for a new trial or withdraw her plea, then the court will consider that.
That's what I was thinking ahead, Judge. And that's why my brain was going like, I don't know if it looked like I was rolling my eyes. But I was like, does that mean that she wants? Yes. Okay.
All
I'll
right.
explain that.
So,
Thank
Rashawn,
you.
if you can, you're welcome. Rashawn, if you can make sure she's referred to mental health court and tell them that even though she's entered a plea here, if they are willing to accept her, defense is going to file a motion for new trial and the court will grant it. All right, thank you. You're welcome. Have a great day.
And I'll explain in a second what she's doing and it's really helping her out. But, you know,
All right, and they'll put you back in the box so probation can speak with you, okay?
Yes, ma'am.
All right.
that's-
It's calling 2023 CR 0223, State of Texas versus Melvin Hernandez. Can I have parties announced for the record for the state?
Jason Garrett, your
Defense.
Albert Chidas for Mr. Hernandez.
And are you Mr. Hernandez?
Microphone is turned on.
Thank you. Are you Mr. Hernandez?
Yes.
Thank you very much. Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case and did you review it with your client?
I did, Your Honor, and I did.
All right, in probation, there's no application in this case. All right, Mr. Hernandez, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do.
State, are you proceeding on the indictment as presented?
No, Your Honor, the state is proceeding, the state jail felony, so we are waiving the enhancement paragraph.
Any objection?
No objection.
Mr. Hernandez, I'm showing you what's entitled Court Admonishments. Did you review that with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes.
Did you understand you're charged with the offense of possession of a controlled substance, penalty group 1, less than 1 gram? That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Hernandez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, punishment is to be assessed at 6 months in the state jail facility. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes.
State?
It is, Your Honor.
Showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence?
Yes, Your Honor. State Exhibit number 1 with all of its attachments.
Any objections?
No objection, Your Honor.
All right, state, you may be excused.
Thank you.
Showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are we proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
No, just that we just want credit for the time that he's been in county.
All right, Mr. Hernandez, it appears that you have a drug issue.
Yes, Your Honor.
All right, how often have you been using?
Since I was 20. I'm
So-
23 right now.
All right, so what are you doing to help yourself with this drug problem?
I went to treatment twice, but I completed it, but then relapsed.
All right, do you have any does he have any violent criminal history?
I think so, Judge. It's mostly drugs related. This-
State, do you know if Mr. Hernandez has any violent criminal history?
He has a family violence case. Not currently.
Not particularly, Judge. It looks like he got charged with adult, bodily injury, looks like a misdemeanor. But other than that, he has convictions for criminal trespass, failure to ID, possession, and possession of marijuana with that.
Okay. All right, Mr. Hernandez, I'm going to give you a choice. You can either take the 6 months in the state jail facility. What's going to end up happening, I'll give you credit for any time served. I will recommend you for the therapeutic community. I will tell you about the free drug treatment they have out in the free world. Or I can give you probation. And if I give you probation, you're going to remain in custody to go into an inpatient facility. Either way, for you, time is going to pass. It's just a matter of how it's going to pass. Is it going to pass for you when you're clean and sober, or is it going to pass for you addicted to drugs? Because at some point in time is going to run out for you. Either, as in this case, you're walking in the middle of the street where somebody could have hit you. Either you're going to end up in an accident where a car hits you, and then somebody is going to want to arrest the person who hit you. Then some witness is going to say, no, he was walking in the street. Nobody could see him. That person will feel bad that they've hit somebody and maybe killed them, but it's not going to be their fault. It's going to be yours. Or either you're going to end up with drugs that are not good. Maybe it's a bad batch. You're going to end up dying from that, or either you're going to end up overdosing, or either you're going to end up spending the majority of your life in and out of custody and in and out of prison. And at some point in time, you're going to get to the point where this state jail felony is going to be a habitual, and you're going to be looking at 20 years prison for what would have been a state jail felony, but for the fact that your punishment is going to be up to 20 years. So the choice is yours. If you want help for your drug treatment, I will place you on probation, but you're going to be going into inpatient treatment. Or if you want to continue on this road where you continue to use and come back, then that's completely up to you.
Take the condition.
Okay. All right. Don't ever go before another judge and say that you were not offered this. And I'm going to write on this docket sheet that I offered you treatment and you said no. You understand? All right. The court is finding you guilty. The court will sentence you to 6 months in the state jail facility, give you credit for any time served, showing you what's entitled trial court certification of defendant's rights to appeal. Did you review that document with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Because this is a plea bargaining agreement,